You brought a lawsuit against your careless doctor claiming that he caused you significant harm and injury. And now the defense denies all your allegations. Your case goes all the way to trial after 2 years of hard-fought litigation. Before starting the trial, the defense recognizes, hey, there's a risk of going to trial, and they offer you $1 million to settle your case. You say, absolutely not. What happens now if your case goes all the way to trial and a jury ultimately comes back and gives you less money than what the defense originally offered? Can you go back and accept what the defense offered before you start a trial? You want to know the answer? Come join me for a walk near the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. You, my friend, have a problem. You have a dilemma. You now have a conflict that you are likely not going to resolve in your favor. You felt in your heart of hearts that you had a strong case. You knew that you had a valid case. And before you could go forward with your case, your attorney actually had to go ahead and obtain all your medical records, have them reviewed by qualified experts, who then came back and told you, yes, you do have a very good case. Okay, the defense didn't see it that way. They also reviewed all your records many, many months later. And they came back to your attorney and said, guess what? We think this case is defensible. We will see you at trial. So now that was the mindset you had over the next 2 years during the course of your entire litigation. You believe that the defense recognized that they did absolutely nothing wrong. And they told your attorney, listen, the doctor feels he did absolutely nothing wrong. And at no time is he ever going to offer to settle this case. Fine. So now you steel yourself. You get yourself ready, mentally prepared, as you get closer and closer to trial, that now you and your attorney are going to have to try this case. And 6 members of the community will have to decide whether you are slightly more likely right than wrong, that what you are claiming is true. If yes, then great, the jury will now go ahead and give you a verdict in your favor. And they will also have to determine how much your injuries are worth. The jury will have to assess and come to a decision, a collective decision, to determine what is the value and the extent of your injuries. So now, as you get close to trial, the defense has their own internal conferences, and they decide, you know what, this is going to be risky. So rather than take the risk that a jury, 6 members of the community whom we don't know what ultimately is going to happen, there is the risk that a jury comes back and agrees with you, and not just agrees with you, but gives you a verdict, a very substantial verdict. So they decide that your injuries are worth $1 million, and they now approach your attorney and they say, listen, Oginski, we are now offering your client $1 million to settle this case. Please relay that to your client, and let's try and wrap this up before we ever have to get to trial. So now you and I have this discussion. We have a detailed discussion about the risks, the benefits, and the alternatives to accepting or rejecting this particular offer. You decide, you know what? Absolutely not. My injuries are worth 5 times, 10 times that. And there is no possible way I would ever settle for $1 million. Fine. So now I go back, I relay the message to the defense, and now they are resigned to the fact that they will have to try this case. Likewise, you now get prepared because now you understand that you will have to try this case as well. Great. So now you and your attorney go forward to trial. Your trial lasts 2 or even 3 weeks, or maybe even more. Your attorney has spent hundreds of hours of his time. He spent countless amounts of money to go ahead and prosecute your case, obtaining medical experts and getting your case ready for trial and actually trying it. At the very end of the case, the jury determines that yes, your doctor was careless. The jury also determines that your doctor's carelessness was a cause of your injury. The jury also determines that your injuries are in fact significant. And now it comes time to give you money to compensate you for your harms and losses and damages. And the jury determines that your injuries are worth only, let's say hypothetically, $500,000. And now you are shocked. When you hear this verdict, you are shocked. As the verdict comes in, you hear one question after the next that is favorable to you. And you are thrilled, you are ecstatic, you are so happy until you hear the amount that the jury has decided your injuries are worth, $500,000. And you are in shock. The only thing going through your mind at this point is, wait a second, the defense offered $1 million prior to starting your trial. And now you rejected that. Guess what? you now think, wait a second, maybe there's a possibility, maybe there's a chance that you can go back to the defense to try and get that $1 million. Can you do that? Sure, you can try and do that, but the likelihood of ever happening is probably zero. Why is that? Because now the jury has decided that your case is only worth $500,000. Now, that's nothing to sneeze at, but in comparison to what the defense has originally offered or had originally offered before you started your trial, it is considerably less than that initial offer. You were hoping that the jury would side in your favor, and now they would give you 5 times, 10 times, 20 times more than what the defense originally offered. And you are hoping that your attorney can go back and not grovel with the defense, not plead, but rather say, hey, listen, we made a mistake. We'd like you to go back and actually ask your client if it's okay if they'd part with $1 million at this point. You know what the response will be? That's not going to happen. Why? Because the jury has now spoken. The jury's determined that your case is worth half of what they were willing to offer. And there's no reason whatsoever for them to offer $1 million. Now, this is something interesting. If we go ahead and appeal this decision and claim that the value of your injuries clearly are not as substantial as we believe them to be, there is a very good chance that now it's going to take 1 to 2 years for this appeal to resolve. And there is the possibility, a good possibility, that the appellate court, the higher court, will recognize and agree with us. And if they do, they could do a number of things. They could increase the amount that you are entitled to receive. They could decrease the amount they believe you are entitled to receive. They could turn around, throw your case out, claiming that there were errors of law made. They could turn around and say, you know what? There were errors made here, and the only way to resolve that with a new trial on damages is to get a new jury and to present your medical proof all over again. In that instance, hopefully you'll get a better result and a better outcome. And now your attorney approaches the defense and says, listen, in order to avoid all those uncertainties of going to trial and having to spend all that money on additional counsel fees and appellate fees, why don't we agree right now to settle this case, or soon after the trial is ended, to settle this case, and instead of the $1 million, we would accept, assuming the client does accept, $750,000. That's something for the defense to consider and discuss. And in all likelihood, they will consider it, they will discuss it, and then they would get back to us. But to go back to the question I raised at the very beginning of this video, what is the chance that the defense will turn around and simply say, okay, you know what, you're right. Let's give you back the $1 million that we originally offered, even though the jury has now spoken and they felt that your case is worth half of what you were originally offered. It's not going to happen. Why do I share this quick information with you? I share it with you just to open your eyes, to help you understand how these types of cases work in the state of New York. You know, I recognize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.